Hi, and welcome to CAM Resource Podcast. Hi, and welcome to CAM Resource. Today, again, we have Steve Mezer. Thank you for coming back out with us. He keeps us legally updated, thank goodness, because there's so much. It's so hard to know everything that's going on. Thanks again, Steve.
Well, thank you, and I appreciate the opportunity to come back again.
So today, well, first of all, Steve, just in case somebody else didn't hear our other podcast or other videos, can you tell us a little bit about yourself?
Yeah, I'm a shareholder here at the Becker Law Firm, and I limit my practice to representing condominium and homeowner associations and occasionally cooperatives and some timeshares, but that's all I do.
Okay, and Steve and I have worked together for many, many years. We won't tell you how many.
Thank you.
And that'll tell you our ages, and we don't know if we want to do that or not. So today we're going to be talking about the July 1st, 2018 legal update. Is that correct, Steve?
That is, yes.
Trying to make sure I get the wording right. And thank goodness, because as I know, I'm a manager, and even probably with the attorneys, you really have to go through these with a fine-tooth comb because it's hard to understand them all. So that's what Steve's here today, is to help us understand them a little bit. So we're going to try to make it quick. We're going to try to do it within 30-40 minutes, but on the website, both the camresource.info and, of course, are these available on your website?
They are.
Okay, and we'll have all that information on camresource.info.
Excellent.
So Steve, let's go ahead and start. What we're going to do today is just kind of touch on a few of the major ones that we know will affect us,
Right.
in detail, but all of the updates are important. Right. So it is, and you're always welcome to call Steve if you have any more detailed questions. He's the better one to call.
Be happy to chat with you if you've got questions, and it's better to ask before you do something than how do we get out of, or we have a letter from the state, we violated something, what are we going to do now?
When in doubt, call your attorney.
First.
That's always my first, ahead of time.
It's less expensive and more effective.
Yes. Preventative legal action is better than anything.
Absolutely.
Okay, so where do we start?
Let's start with condominiums.
Okay.
And we'll break them into condominiums and homeowner associations and a reference to the cooperatives as well. Condominiums, we start with the official records.
Okay.
The legislature seems to address this every year, trying to fine-tune it, and they've made it more difficult, I think, in application. For example, one of the changes is that minutes and documents that were obtained at turnover must be kept perpetually. Now, I don't know how you as a manager would go back to the beginning of a condominium and say, okay, now I need all of the old minutes. I need everything that we got at turnover if it occurred more than 7 years ago, because the minutes, at least, were under a 7-year statute before, and now it's perpetual.
Mm-hmm. I know I found that a lot. I just went to an update with the actual department, and they were saying that too, that there is a problem, because if you didn't have to have them before, you're sometimes lucky people kept them, but people tend to throw away old stuff quite often, so.
And the time for providing documents has been extended from 5 days to 10 business days. Mm-hmm. This is important because people used to play games with that or be found in a very uncomfortable position when you had 5 days to produce it, and you may not have learned about it until the third, fourth, or even the fifth day or later. So it becomes more user-friendly for everybody to go with the 10 business days.
More realistic.
Absolutely.
Because just preparing for somebody to come in and look at the records is very time-consuming.
As you may recall from last year, there is a new requirement for condominiums that have 150 units or more to have a website with certain portions of the official records and some other documents on that website. The website has to be password protected for the unit owners, and it has to have for example, you and I were just talking before about the bids and bid summaries. And what's that going to do for you as a manager to have to post a bid summary?
So that's what Steve and I were talking about, the whole idea of taking bids for, let's say, a contract, and now they have to be disclosed on the website. And what's our procedures to do that? It kind of, I think, says in there, correct me if I'm wrong, but a summary.
It does.
So I think, Steve, did you feel that we should just post the bids?
I would post the bids
that's just
because
easier.
Absolutely.
Yeah.
The statute says bid summary, but what is a summary? It's not defined, and many managers might default to just the typical spreadsheet.
Which is what I was talking to Steve about. That's usually what I provide. But Steve said just to be safer, just post the bids.
Absolutely, because you'll have terms and conditions that will vary, that may later on become important. Somebody may use subcontractors, day laborers, they may not have the same insurance, warranties may be different, and you could never cover all of the key issues you couldn't anticipate what they're going to be anyway in your summaries. So for the protection of the manager and the association, please post the bids. And those bids do not get posted until the bidding has closed. So you don't have to post them upon receipt and say, well, this was the first bid, and that would give an unfair advantage to the person who may have timely bid as the last bidder. But that's going to be an interesting dynamic.
I'm going to wait to see how this goes, because I worry about the bidders themselves having those disclosed. Also, you said something interesting, Steve, about subcontractors. I noticed that a lot of times that's not even mentioned in the contracts, and they need to be, because that's so important for the association to know whether or not they're subcontractors, because you have to get workers' comp information from everybody. So that's why you're doing that. Just make sure that part's in the bids, because as you said that, I thought, oh no, that's even putting more liability on us, because later somebody's going to say, well, you didn't even make sure that was in the bid.
Right.
So I think we really need to hone in on that right now and really go through our bidding process and make sure we understand that. Maybe we'll do another video on that. How's that sound?
Absolutely. Let's do that. Let's move on. The financial reporting. Last year, they had a new provision that if in fact you did not get your financial reports to the owner's timely manner after they had requested them, the owner could complain to the state, and from that point forward, you could never waive the audit reporting requirement, which became quite cumbersome and expensive. This year, they modified that to just be applicable to the next 1 year.
Yeah, because I tell you, a lot of times, even though we try to hire good CPAs, we try to change it from time to time, sometimes they just do not get them to us in time. And no matter how much we panic and scream and everything else, we just don't get them in time. So it's pretty scary sometimes.
Absolutely. And you think about it, the audits are normally due in the spring, someplace near April 15th. And if that CPA firm also does taxes.
Yes, exactly.
Okay. Or if they concentrate only in condominiums, they have a lot of them to do, and some of them are more and it's not our fault. Yours, mine, the boards. It's the CPAs are busy and they want to do a good job, and it may take them a little longer, and we have no control over it. Yet you can pay the penalty, literally.
So you have to be the squeaky wheel that gets oiled.
Let's move on to special assessments.
Okay.
Now, I know you're a good manager, an excellent manager, so you already did this, but the legislature had to come through and say that when you do a special assessment, the notice must include the nature of the project to be done and give you an estimate of the amount that is going to be special assessed, because we've seen other folks who will just put on the agenda consideration of special assessment. They didn't say what it was for or how much it would be, and it's really not fair to the unit owners to do it that way.
It's important that they understand it, because you don't want them to get upset later on, after everything's done. And also, if there's extra funds, you've got all that disclosed ahead of time.
What to do with the surplus. And that's a really good point, that when you do a special assessment, always consider what is going to happen to the surplus. So that
right in that same meeting.
Yes. Determine it up front. Otherwise, you will have a dispute. Do the owners get that money back? Should it be put into a reserve? Should it be applied to other items in the operating account? So yes, just go ahead and dispose of that issue up front. And even though you may not have the surplus.
Right. Hopefully you will. And if you have it on the agenda, you don't have to worry about it later. You can just maybe move it right into your operating account.
Absolutely. Moving to term limits. 8-year term limit, and they said that you could only do 1-year terms, and it became quite an issue for so many people. First of all, that's not retroactive, and so
okay.
Everybody last year you were starting in year 1. Well, because they amended it again in 2018, July 1, 2018 became year 1 for everybody if you're on that 8-year term limit.
Okay. Thanks for clearing that up.
And, it's 8 consecutive years. Well, you and I know that it's hard to find good board members. And so there's going to be typically during that 8-year span, a time where after the date for qualifying has closed, that you have either the same number of candidates as you have openings or even less.
Yes.
So
even less.
I'm going to tell you how to get around the statute.
Okay. Can you?
Just go ahead and resign during that window. It's day 40 to the election. That person can resign, and then he or she is automatically back on the board because they qualified, and now they have another 8 years.
See, that's why these things are important. And now these are still for condos only?
Yes.
Okay.
Again, not well written, not well thought out.
Yes, because sometimes it's hard to find board members.
It is.
And mostly if the association is running well, it's even harder because people are complacent. They're happy. It's when everything starts going wrong, then people will pop up.
Right.
So.
I think what happened here was we have term limits for legislators, so they wanted to share.
With
Yeah, we're all in that way, yeah.
Throw us into the pot.
They did touch on condominium recalls. They have changed that process slightly, and they're dealing with facial validity of the petition, which is not defined. There is a provision for attorney's fees now for when the director who is being recalled challenges it and wins. He or she can get their attorney's fees covered. But you got to look at that carefully. Who are they going to get those attorney's fees from? They get it from the respondents, who would be the association.
Okay.
So everybody pays for it.
Everybody still pay, yeah.
Or the owner representative, and I suspect that the arbitrators will tag the association for those. If the challenge is found to be frivolous, the director could have his or her attorney's fees reversed. Actually, they're paid by the other side. So they've got to be careful what to do with those. Move to material alterations. New provision, effective July 1. If you're going to have that owner vote, in other words, you're doing material modification of the common elements, it must be before you start the work.
Which should be logical. You should get the vote before it's done. Now, what about an emergency situation? That would be excluded, or let's say, hurricane or whatever.
Right.
Okay.
Because that's maintenance and repair. Okay. That's not a material modification.
That's true. Yeah. That's true. Yeah. So
usually.
Yes.
You know,
bringing things up to code, possibly. Okay. All right. Because that's what I've found sometimes. Bringing things up to code will change it.
Exactly.
If it's emergency, but if not, disclose it way ahead of time.
Right, and get the vote.
Yeah.
It really precludes you from doing what was fairly common, which is to do the work and then get the vote. One, you say, well, who's going to reject this beautiful modification we're going to make to the lobby? Or who's going to want us to remove it once we put it in? So they'll all vote in favor of it later.
So if your lobby's green and you want to paint it blue, do you have to? Yep. So remember that.
Yeah, absolutely. And when in doubt, get the vote. It's so much easier.
You have to put up the paint in the beginning, but it'll be a lot less than if you wait. You'll get a lot more.
Exactly.
Yeah, and afterwards.
The next one on the condominiums deals with fines. You probably know I like fines.
I do too. I have to say I don't like doing it, but sometimes it's the only way you're going to get things done. That's it. You just have to do it.
Yeah, I like it from the perspective of it's being local. In other words, it's the unit owners who make the decision, not the person downtown in a robe who sometimes gets it wrong.
Yeah. Yes.
They may not share the same values as the people in the condominium. What's important to that judge may not be important to you, and vice versa. So you want to be on the same page with your condominium.
And also uphold your rules, because they're so important. And if a judge goes the other way, it hurts everything.
Right. So what the new statute says is that committee hearing that happens 14 days after notice, if they approve the fine, it is due 5 days after that. So that removes the ability of the board and the committee to give somebody a payment plan or to give them 30 days to pay. The statute establishes the due date as 5 days.
Which is great.
Yeah.
Because you'll say, hey, we don't even have the ability to let you.
Exactly. They've taken away the discretion.
And I do recommend fining. Make sure you have all your committees properly in place and everything. But yes, it's sometimes I feel like it's just the nature of it. But sometimes they think we're gnats, so just go away until they realize, especially like in HOAs, not only will you get a fine, but you could lose your house.
Yeah.
You could lose your home if you don't pay it, and then they start taking it serious because we have to uphold the property values. It's so important.
Right. And that's a good point. The collection of the fines is typically through small claims court. In the HOA, if the documents support it, it can be through a lien, which could cause the loss of the home. Judges are fairly well trained in this and understand that all they're looking at is the process. So if you got fined for the dirty mailbox, dirty driveway, other violations, they're not going to listen to your explanation as to why your driveway was dirty and your mailbox wasn't up to standard. They just want to look at the process. Were you properly notified? And they gave you the 14-day hearing. Everything's documented.
And I've been through a few, and it goes through. If you've crossed your T's and dotted your I's.
Right.
So I think it's great.
Yeah. Just briefly on the cooperatives, in this legislative session, they have brought the cooperatives more in line with the condominiums. They're kind of the redheaded stepchild of community associations. So I would just say, look at the changes for 2018 if you are a cooperative association, or contact us and we'd be happy to discuss the application. There are things in there about the official records, board voting. I'm trying to think what else they have. Committee meeting notices, electronic notices, and things that were already in existence for the condominiums, and they just moved them into the cooperatives as well. Want to go to homeowner associations?
Good old HOAs.
HOAs, Chapter 720. The first one dealing with emails. It's the modern times. People do use emails, but you can't vote by email.
Don't do it, people.
Please.
Don't do it. I know it's so easy to do it, but just don't, because you're going to get yourself in trouble. You have to always put yourself in the homeowner's position. That's really making a decision without having them knowing what you're doing.
Yeah. Yeah, Florida is known as a sunshine state. We have a sunshine law. It's for the governmental entities, but you know what? They imputed that into the HOAs as well, and condominiums and cooperatives, that you conduct your business in the sunshine. And they can't see those email votes, but I'll give you a little twist on it. In the Corporate Act, there's a provision that allows for action by written consent. So if the board, and typically we see this more with developer boards, but we've got condo HOA and cooperative boards that will do an action by written consent. So now that this statute is in place both in condos and in HOAs, can they do a written consent by email? And
I would call you for that answer.
and my colleagues and peers are split on it, and I'd be very careful. I tend to come down on the side that it can be done, but I would really
just make sure that and it really should be. I mean, if for some reason you can't have a board meeting, call your attorney and talk to him about that first, because what is it really that can't wait until the next board meeting? Unless is it on borderline emergency or not? And is it already in your budget that you can just do it? There's certain things like that. So
yeah, and I would rather that they do it on a short notice meeting and ratify it later, or something else other than doing the written consent. I'm not a real fan of that process.
Speakerphones work great.
Yeah, exactly.
Have a meeting really quick, call everybody and get it all on a conference call.
And with your iPhone, you can join 3 or 4 people with your call and just get it done. There's really no excuse for that anymore.
And you can call your phone company, and your phone company will set up a conference call with the phone number that they all can call into.
Or your lawyer or your manager.
And post it.
Please. Okay, back into the HOAs. Last year and the year before, we were dealing with amendments to the governing documents, and that they had to be sent to the owners within 30 days after recording. And then they said, well, if you mess up on that, it's still a valid amendment. This year, they've added the requirement that the notices go to the address of the owner as found in the Property Appraiser's Office. You know that one well.
Well, because I always use that when in doubt, because sometimes, you'll hear people had a divorce, somebody died, so we use that all the time. And then, so we were used to using that, but then I was kind of glad to see that happen. But after this took place, we're actually going in and we're finding a big discrepancy on what's at the property appraiser's office and what's. So we're checking all of our accounts. I know that's overwhelming, but you might want to do that on a regular basis anyway. Do so many at a time.
Absolutely. And particularly before your annual meetings, there was a case in Pinellas County where somebody challenged an annual meeting because the notices did not get sent to the correct addresses, and it was only one person. And what happened at that meeting, one vote would not have made a difference.
That's what I was about to say. When it's one, you don't think about it. Most of the time you're oh well. But when and it has happened, where one vote will make a difference between who's on the board and who's not, and that's when it'll get challenged.
Or whether an amendment passes, or whatever action was taken by the owners, and you have one person, maybe it was a change of ownership or something else. So notices really matter.
Yes, and another thing that I noticed a lot is a husband and wife will live there for years, and all of a sudden something will come in question. You'll go to the property appraiser's office and you'll notice that husband or wife isn't even on the actual deed.
Right.
And check, because a lot of documents require that you're on the deed to be a board member.
Correct.
If you're not on the deed, which you're not on that property, they might not even be a legit board member. So that's why it's so important to go on there.
And sometimes it'll just say must be a member of the association, and that's legalese for must be on the deed.
Yes, so it's good to go in there. Also, I don't know if you've been on there, but now today, especially in Pinellas County, I don't know, I've seen them in a couple of counties, they have the actual property where used to you didn't know where the lines were, but it's very clear on there now, and they're even becoming more detailed with that because they're getting ready to charge everybody per lot size. So that's good. Sometimes if you don't know where your property line is, now you can go there in that same little area and see a lot of that.
Absolutely. And sometimes that has to do with maintenance, if you're going to maintain to the sidewalk or to the street or outside the wall.
Yes.
Yeah, it's all very helpful. Application of payments. This was in the Condominium Act. Actually, it started in the HOA, then went to condominium. Now it's back to the HOA. People can write all kinds of things on their payments, payment in full for the rest of the year and releasing all claims and things like that. This basically says that regardless of what it says on the payment, you apply it the way you were told to by the statute. Interest costs, attorney's fees, late fees, then the assessments. That, by the way, probably conflicts with the federal statutes. The federal law says that you have to follow what the debtor says. So if I have not paid for the first 6 months of the year, and I decide that I want to pay the July assessment, and I write down July assessment, you should, under federal law, follow what it says on my instructions.
But this contradicts that?
It contradicts it.
Okay, so let's go with the statutes, right? Or what do you think?
Yes.
Okay, good. Okay.
I'd be very careful with that. I would probably talk to the association attorney on a case-by-case basis. Are you being set up for a federal lawsuit? Or is this just a good faith mistake where they thought they paid the first 6 months of the year? or maybe they're challenging the first 6 months of the year because you had an illegal board or your assessments were not imposed correctly.
Or they're thinking their account balance is wrong or something.
Right.
Okay.
So let's look at those.
Okay.
HOAs, the Marketable Record Title Act has been out there. You can Google Marketable Record Title Act, Florida, and you read all the horror stories. Some of the best ones are from St. Petersburg, where deed restrictions under the Marketable Record Title Act, which is Chapter 712, lapse after 30 years. And they just go away, and people come to court or they go to their manager or their attorney and they go, oh, these restrictions have not been revitalized or revived under the Marketable Record Title Act. You have no restrictions. You can't enforce those anymore. Or an owner may use that as a defense. And
I found that a lot because a lot of the associations here are over 30 years old.
yes.
So they all just weren't valid anymore.
Exactly.
You had to go and preserve them all. So.
And that's the recommendation to those folks who are watching or listening, is that don't let that 30 years come up on you so that you have to spend more money and go through more
It
legal
does
steps.
cost you more if
A
you
lot
let it
more.
lapse. But if it has lapsed, still do that because it could put you in
Yeah.
jeopardy if you.
There is a movement among some of my colleagues and peers to find that statute unconstitutional, so be very careful, because it's a retroactive impairment of contracts and vested rights, and it's a fairly complicated legal argument, but it is out there, and I think they have a good case.
When this all started happening to a lot of the associations I was associated with, I thought, why would they even make them, not valid after 30 years? What was the thought of that?
To clean up title searches and make it easier. The 2018 change was to allow amendments. If you have an amendment to your declaration, that can be your extension of your documents and get you out of this 30-year lapse cycle.
Good to know.
And one other thing before we close on this, the new statute requires that boards every year at your first meeting after the organizational meeting consider MARTA. It's
Okay, great.
totally useless, but nonetheless it's there. I mean, you have to do it because it's the law.
So preserve your documents. Definitely check into it immediately. See
Right.
where that is in your documents. Usually, is it average about 30 years?
Yes.
Okay, 30 years. Okay, all right. Anything else, Steve?
No, that's it for today, I think.
All right. Well, thank you so much.
Sure.
Hopefully, we've kept it short and quick for you. There's a lot more details, which you can surely go to either website. We'll have all of Steve's information there, and we'll definitely be back with you with some more information. Hopefully, Steve will talk to us about some other things.
Be happy to.
All right.
Thank you,
you.
Diana.
Thank you.
We hope you found it helpful and informative. As always, you can join us at camresource.info for more episodes, or go to our YouTube channel, Cam Resource. See you there.